Morning, Mr. Houlihan.
More.
How's jail?
Sucks.
Good. Wonderful.
Definitely don't ever want to come back here.
The worse of an experience you have, the higher likelihood you have of truly listening and realizing that we mean business, because that's what we do. When we ask you, when we tell you not to do something, it's not for shits and giggles, it's for the real deal, and you're not supposed to. And when you do, there are serious consequences. And coming in here and tell me it's NyQuil or this, I don't care. No alcohol means no alcohol from any source. Now, at the same time, I don't want you to plead guilty just to get out, right? Because that's what you were going to do, and that's what everybody does just to get out, and I don't want that to happen. I'm going to give you another chance today. I'm going to put a monitor on your ankle so that I know that you're not consuming alcohol. And I'm going to tell you now, I will never play this game again with you.
Yes, sir.
So the next time.
Pause right here. This is the judge drawing a hard, unmistakable boundary. Notice how he's shutting down every excuse before it even forms. Nike, hair dye, tequila lollipop. Legally, this matters because probation conditions are strict liability. Intent doesn't matter, only compliance does. Question for you. Do you think people truly understand how unforgiving these conditions are until it's too late?
You consume alcohol, and I don't care what source it is, and you've got your mom here to know. Whatever it is, I don't care if it's the tequila lollipop, hair dye, you had dinner with Mother Teresa, whatever. The next time you consume, you will be with me. And you know now, you have no one to bond you out. So you're going to sit there for who knows how long. Do you understand?
Yes, sir.
No alcohol whatsoever.
Yes, sir.
The monitor that I'm going to put on you costs around $400 to $500 a month. I'm going to waive that fee for you so that there's no excuse. You need to charge that thing on a daily basis. So if the battery goes dead, so do you. You must charge it on a daily basis. Be careful for whatever you put in your body because that machine is extremely finicky. It tests alcohol through your perspiration. So whatever you're eating, be careful. Apples, what happens to apples? What happens to bananas? They can become alcohol at some point. So you need to be careful. Apples, some fruit ferments. So just take that with what it is. Be careful whatever you put in your body.
Yes,
Are there
sir.
instructions somewhere that?
Yeah, they will advise him when he gets the monitor. They'll advise him on what he can and can't do, but it's also common sense. You have to know everything that you put in your body. If you're going to go to a party and there's a bucket of punch there, probably not a good idea to drink the punch, right?
Yes, sir.
Okay. Just use common sense.
Yes, sir.
It's not that hard, and be nice to people.
I definitely love him.
I'm letting you out now.
I don't want to end up being like my father.
That right there gives you pause to concern. I mean, you're headed there. I mean, you're in jail. You're headed there. I mean, if there's no other wake-up call, then this is the wake-up call. Don't end up like that.
This is a rare moment of the court actually trying to save someone from their own future. Diversion programs aren't just paperwork. They're an exit ramp before a permanent criminal record shuts doors for jobs, housing, and education. The judge isn't being dramatic here. He's being practical. Would you take this opportunity seriously if you were standing there?
You have the opportunity now to apply for a diversion program that if you get in, which you probably will if you do the application correctly, if you complete it successfully, they'll dismiss this case against you. It's a really big deal because when you get a DWI on your record, it closes so many doors. Not to mention your life, it's going to cost more in every respect. So just be good. All right. Yeah, drug testing as well. You're going to be tested 40 days from today. If you find weed in your system in 40 days, that tells me that you've continued to smoke weed. I'm going to put you in jail. Don't smoke weed. Don't go to any parties. Don't hang out with anyone that you think that they're going to use because peer pressure sucks and it's very, very difficult. So if you're hanging out with the wrong people, they're going to take you down. No dope, no alcohol. You'll be tested in 40 days. And you know now what that machine does.
Yes, sir.
Do you have any questions? Okay. Listen to Mr. D, and then we'll see you in a couple weeks. Thanks for coming, man. Do you have any questions?
No,
I'm gonna set up.
Remember, be patient with Mr. Dixon. He has so many cases. I mean, you see, he's running from court to court to court to court. He's like Speedy Gonzalez. So just take care, understand he has a lot of cases, and that if you call him, at some point he'll get to you. And
I'll meet with them in my office this Sunday.
and if you can always come here and meet here as well. We're always happy to have you at any time as well. Okay? All right, guys. All right, good luck, Mr. Delaney.
All right, sir, this way for me.
Thank you, Your Honor.
Thank you, Mr. Dixon.
Judge, for clarification, 40 days for.
You have taken off on me 3 different times, Mr. Osborne. If you think that we are going to give you a PR bond, you are charged with assault, bodily injury. You're facing a year in jail. You had an offer in this case where they were going to dismiss this case, and you have repeatedly taken off, not once, not twice, but thrice. I am not going to give you a PR bond, and we are taking you into custody now. Your bond is now set at $10,003 because of all the times that you have taken off. And I get that you're in high school, but the problem is that you have already taken off 3 times. If I let you go now, what does that tell you? What? It tells you that it's okay for you to do what you're doing and not to hold you accountable. And that's not what we do here. You need to understand that courts are here for a reason. We do court orders for a reason. And when you fail to comply, when you fail to show, there are real world consequences. And I don't know if you have anyone that's going to bond you out. If not, you will be stuck like Chuck with me.
This is where accountability fully kicks in. Missing court isn't a small mistake. Legally, it signals risk. 3 missed appearances turns sympathy into custody, especially when the court already gave chances. Judges look at patterns, not excuses, and once that trust is gone, everything changes fast. Do you think the system should be this strict, or is this the only way to make court orders matter?
Until this thing is over. And I'm going to tell you now, I'm not into this pleading guilty, time served just to get out, just to ruin your life. I'm not going to let you do that.
We accepted the PTI. The states said they would still do it. We accepted the PTI.
I get it, but I'm not letting him out.
Actually,
I mean, it's 3 times the case. How old is this case? It's a year old, and
you set your bond at 10,000, so you need to post 1,000 worth of bond.
well, I don't know, because whatever they're going to charge you, I don't know. You're a flight risk. They may charge you more.
Can I ask a question?
Sure.
I don't recall, leaving 3 times.
You have a criminal case. You know that you are supposed to keep up with it. There's no out of sight, out of mind. You should have enough wherewithal to say, you know what? I haven't had court.
All you're gonna do is mess up yourself. This ain't the place where you ask questions, okay? All right.
You should have enough wherewithal to know, you know what? I have court and I haven't heard in a long time. What's going on? The only reason you are here now is because what happened?
Bonding company's attempting to get the case reinstated and or a new bond set for them. That's it. We wanted to let the court know it was our fault for not notifying him of
I'm
the
not
May
going to
setting.
all of the sort. It's not your
I
fault.
do understand. Yes.
You know, if it was one time, okay, but we have 3 different times. It's unacceptable. Okay,
If I may,
sure.
he did miss court 3 times, but he missed the first one because I couldn't reach him because the phone number I had was disconnected. I reset it 2 more times to try to get in contact with him. So he didn't purposely miss 3 court dates, is because I couldn't. The phone number I had for him.
He
wasn't
knows he has court, Mr. Schofield.
I understand.
You know,
I just-
Behavior has consequences, and now you're going to see that there are serious consequences to it. He goes with you. I'm not out for blood, but I want him to understand that we mean business. If he is unable to make a bond by tomorrow, then we can talk, and I'm happy to entertain perhaps something tomorrow. I get it that he's in high school, but I want him to understand that we mean business. And if I just let him go now, it's enabling him, and it's not a good thing. But I'm happy perhaps tomorrow, if he's unable to make bond, we can talk about a PR bond tomorrow.
Should we just set it for review for
He's
tomorrow?
going to come back tomorrow regardless because they'll auto-populate,
Okay.
because that's what happens when we take someone into custody, they auto-populate for the next day. So we can talk about it tomorrow about,
Okay.
because I'm not going to let him plead guilty just to get out and just to get a conviction on his record. And I'm happy to do this, but I want him to understand that we mean business and we're not playing games. So if he's still here tomorrow, we can talk about doing a PR bond and we'll let him try that. But I'm going to tell you now, he gets an ankle monitor, curfew, and I'm going to drug test him. And I'm going to be his dad. That's it. Okay. All right.
Thank you.
Mr. Johnson, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Officers were dispatched in Harris County, Texas. The complaining witness was downtown in Houston to celebrate her birthday that late evening and had consumed a moderate amount of alcohol while out. The complaining witness stumbled and caused an item in the bathroom to fall. The defendant entered into the bathroom and became aggressive because he thought she had been throwing things around on purpose. The defendant grabbed her using both of his open palms and grabbed the base of her neck and began squeezing it to the point she was unable to breathe and caused her pain. The complainant stated that the defendant, then released his left hand from her neck and then used his right hand to press her head against the edge of the bathtub. The CW stated that
So the bathtub, you say?
on the edge of the bathtub, yes, Judge, that's what it says. The complainant stated that the defendant then struck her multiple times in the face with his left hand and caused her upper and lower lips to become swollen, bruised, cut open on the inside of both upper and lower lips, and caused additional pain. The complainant stated that the defendant also struck her in the right eye with either an open or a closed fist, which caused her even more bruising, swelling, and redness to appear.
What's the relationship?
It doesn't appear that there was one, Judge.
The complaining witness and the defendant were in a dating relationship at the time. They're no longer in that dating relationship. I just spoke to her yesterday.
Were they in a dating relationship at the time?
Yes, Judge, at the time of the offense. When he was told yesterday.
The wrong charge, Judge, again. I don't know what to say.
Mr. Johnson, it's very possible that they indict this as a felony. I would be very, very careful because it could be very well is an impeding choking case where you'll be facing 2 to 10 in the penitentiary. As it stands, I'm sending you for a drug test right now. I want to know what, if anything, is in your system and you're to come right back. If you fail to take the drug test, if you fail to come back, I'm going to revoke your bond and I'm going to make it high. Do you understand? No more PR bonds for any new charges, anything you pick up, any violation of conditions that you may do. You're not going to get any more PR bonds. Do you understand? And I'm going to tell you now, I'm going to do everything in my power to protect my city at all costs. So I'm going to have you sign a reset and we're going to send you for a drug test and we'll see you back in 30 minutes. That way.
Page 18, Mayfield.
I'm going to test you 40 days from today. If you test positive for marijuana again, I'm going to revoke your bond and put you in jail. If you test positive for alcohol again, because I'm going to randomly test you, likewise, you will go to jail. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm ordering you to work full-time or get into school full-time as well. No contact with the complaining witness in this case. Do you understand? And I'm telling you now, it's very possible that they indict this as a third-degree felony. And if you have any prior pen trips, you could be looking at a serious 15 to 25 to life case. But like I told you before, I'm going to do everything in my power to protect the public at all costs. Do you understand? THA? And then he comes back and we test him in 40 days. Do you have a Texas driver license?
It's expired, but
And you are not allowed to drive. And I'm making it a condition of your bond that you're not to drive. And you will be signing an affidavit with me. You just had a tampering with a government record dismissed 3 months ago. So I'm ordering you not to drive as well, unless you have a valid Texas driver license and liability insurance. And I'm going to have you sign an affidavit with me today, promising me that you're not going to drive, Mr. Johnson. Sorry?
I got a question. I got a question.
Shoot.
I used to tell you like this case has nothing to do with drugs or like driving. I didn't get in trouble for no drugs. I have never got in trouble for drugs or drinking or anything in that matter. I never in life got in trouble for it.
I don't want you using while you're on bond for this case, and I don't want you using and being in a state that could potentially lead to other charges because you're in a state that you shouldn't be. So if you have problems with drugs or alcohol, you better address it, Mr. Johnson, because if you don't, I'm going to do it for you.
I'm not saying I have a problem. I'm just trying to see like this case happened. I think they said in what?
When was it charged?
Yes, ma'am.
I get it, but Mr.
April 17th.
You know, listen,
Hold
on, Mr. Johnson.
Since like with no alcohol or no marijuana, nothing.
Resisting arrest, assault of a family member, possession of a dangerous drug, possession of marijuana, unlawful restraint, theft, possession of a controlled substance, out-of-state fugitive case, harassment, out-of-state fugitive case where you had a desertion from LA County where we gave you a $60,000 bond, tampering with the government record, and now another. I'm not going to argue with you. I want to do everything in my power to keep the county safe. And if you're clean, I'm not going to, this is what's going to happen. I don't want you using alcohol. I don't want you using any illegal drugs. I don't want you to have contact with her. If you don't have a Texas driver license, don't drive. If you don't have liability insurance with your name, don't drive. I'm asking you on every single one of those things, I'm asking you to follow the law. I'm asking you to be a nice and good person out there. That's all I'm asking.
Do not talk to the prosecutor.
I didn't know she was the prosecutor.
Don't talk to the prosecutor.
Thank you.
You need to talk to the You just say THA, you're on the right. Yep. You need a higher end attorney, that's what the judge is saying.
I think, I don't work, so
One of your bond conditions is that you get a full-time job, Mr. This isn't up for negotiation. These are your bond conditions. I want you to become a productive member of society. That's it. So I'm going to have you now sign this affidavit promising us you're not going to drive. I will get you to Victoria, sign a reset. After that, I'll get you with pre-trial for your bond conditions, and then we'll see you in 30 days.
But I just want one more question. So when I come back to court, is this just for the drug test or just like the
Just make sure that you're in compliance for you to have a lawyer. And then in 40 days, I'm going to drug test you again. So don't smoke any more weed after today. Okay?